And for the record, the judge has abandoned court. This case is dismissed. I order this case be dismissed. Case number 25-1756-SM.
Hey guys, welcome back to the channel. So clearly we are in the old office once again, and there goes Savannah. We're back in the old office. The other one was just too big and too echoey. And as the first video, we are going to go back a day. We're going to go back into the Wayback Machine and go back a day to Eric Martin's hearing with Judge Shackleford. Ugh, can't talk today. Because it was a good example of how dumb Eric Martin is. Not in the normal sovereign citizen way, but if you stick around for the last minute of the hearing that I'm going to show, he actually, spoiler alert, he is in the middle of someone else's hearing, still trying to get Judge Shackleford's attention to talk. Raising his hand, shaking his hand, raising his hand again. And I'm going to show you that. And I might cover the bookend hearing, where it took place a little bit before and a little bit after, because old boy was where he wasn't supposed to be. But, yeah, I might cover that one as well. But Eric Martin just cannot get out of his own way. And I think it's funny. And again, we all know Eric Martin has a Facebook page. Do not go and harass him. I know a bunch of people have gone over there and left comments. I'm telling you don't do that. But you guys are adults. Do what you want. But this guy can't get out of his own way. So we're just going to roll with this. It's about 12 minutes long. So just sit back and enjoy it.
Mr. Martin, wait a second. Okay.
Yeah, okay. Well, I would like to start talking now, maybe so I can have enough time to talk pursuant to my First Amendment right.
Hold on. Okay, now we're on Eric Martin. This is 251756, the People versus Eric Martin.
Good morning, Your Honor. James Gazicki on behalf of Mr. Martin. Your Honor, he's waiving his right to a trial by jury, requesting trial by this court. And also, can I address bond, Your Honor?
Yeah, I signed the order granting discovery. Mr. Martin, you understand that you have a constitutional right to a trial by jury?
I comprehend that.
Do you understand that, sir?
I comprehend it. I just want to add, as I told him, I really don't consent to no jurisdiction of this court, but since I'm being forced to make the choice, I'm saying an Article 3 judge is going to be the choice, the forced choice. Article 3 judge.
All right, guys, let's break this down for Eric Martin and all the other sovereign citizens that keep getting lost in the weeds. And if you hear a small child laughing, it's because Savannah's next to me laughing. So, Article 3 refers to Article 3 of the Constitution. I know, shocker. The section of the Constitution that authorizes a federal court system. This provides that the federal courts have judicial power over all cases and controversies arising under the Constitution, laws, or treaties of the United States of Admiralty or maritime jurisdiction. And there she goes. Yeah, you see how that doesn't have anything to do with the State Court of Michigan, which the Constitution of Michigan kind of like created. So I don't see how Eric Martin allegedly beating his sister, I don't see how that's a federal court issue. It seems like the judge, shocker, is correct when she's like, no, I have jurisdiction over this.
Okay.
Even though the case shouldn't go, let me mention this too now. The case shouldn't even go that far. We shouldn't even be wasting taxpayers' money, nor my time in here. First of all, I proved my sister lying before on me with the same type of charge, Nessick, okay? I don't know the case number right now. I asked Jasinski to find out what it is. But in the same court, 23rd District Court, the judge is seeing she lied when I questioned her. Did you swing at me before I kicked you? She answered no to that. And it was seen on the camera. She lied. This is especially why I should not be made to wait on this.
I know, guys. I'm a bit eager, so I'm breaking in a lot here. So let's throw this over there on that screen, which is way too far away. We're going to go look up Eric Martin in the 23rd District Court case search. So, this is this case. And yes, it is the 14th at 10 a.m. This was a case of some traffic shit that he just paid, I believe. And I highlighted it. I believe this is the case he's referring to. He had 2 domestic cases going at the same time against his brother and sister. And on, I believe, like the day of the trial, neither of them showed up. So he didn't catch anyone like lacking or catch anyone slipping. They probably felt bad that they were going to throw their mentally disabled brother back in jail or out on the street. So they probably thought, hey, you know what? Let's just not show up. It'll get dismissed. We'll give this guy, another shot. And then he did the same shit again.
Mr. Martin, you have a constitutional right to a trial by jury. Are you voluntarily waiving the right to a trial by jury?
Since I'm being forced to make
Well, you're not being
answer.
forced to make any choices.
Well,
You can
I
have a
make one or
trial by...
two, so I am being forced.
Mr. Martin, listen, we can get through this, or we can go back and forth, and then I end up muting you, and then that's how we go forward. So let's see if we can do this without that, okay? You have a constitutional right to a trial by jury on this case. Are you waiving your right to a jury trial?
Yes.
And you understand that I'm the judge of the court, that I will be the trier of fact on your case?
Well, I want a motion for the judge trial, but I'm going to object to you being the judge based on past constitutional violations.
Okay, well, your motion for recusal is denied. So now, Mr. Martin, are you electing for me to try the case, yes or no?
In that forced sense, yes.
Well, you have 2 choices, a jury trial or me. Out of those 2 choices, which one do you like?
Are you an Article 3 judge?
Mr. Martin, I'm not going to entertain jurisdictional arguments. I'm asking you, do you want a trial by a judge or a jury? And I'm being very patient.
By a judge, I already said Article 3 judge. Article 3 judge.
Okay, well, I will be your judge. I've made that clear. This is a case I have jurisdiction over. It's a misdemeanor that's alleged to have occurred in the city of Taylor. So you're indicating to me that you're relinquishing your rights to a trial by a jury, and you'll be tried by me. And you understand, you've had a chance to talk to your lawyer about this, Mr. Martin?
Yep.
Okay.
I also want to make it clear, I have some other things to say. I enforce my right to a Republican form of government under Article 4, Section 4 of the U.S. Constitution, which is why the court don't have jurisdiction over me. And I am the third party beneficiary here. I am not the defendant.
Amy, can you find
Despite the fraudulent presumption otherwise.
Possible.
Eric Martin, you are the defendant. You are the one who allegedly put hands on your sister, got arrested, got released, got rearrested when you decided to sneak in the back door in a place you weren't supposed to be. You are the defendant. Seeing as how you are currently sitting in jail, you are the defendant.
All right, give us a second, Mr. Martin. I'm trying to get your jury trial date. We can even do on a state date.
I want to make clear, I'll point out, it's supposed to be 28 days, and Saturdays and Sundays are not supposed to be excluded. Because the 28 days is specific for speedy trials and misdemeanors. And since that's specific, under the court rules, it should be 28 days without excluding Saturdays and Sundays or legal holidays. That's made clear, I want to say, under the rule that dictates speedy trial, MCR 6.004C, and also MCR 1.103, the applicability rules, that clearly says, where a rule is specific, it applies to that. So the specific rules control over general rules.
Okay, Madam Prosecutor, how many witnesses? I would say maximum. Okay, Mr. Gazicki, how many witnesses?
Your Honor, first of all, I just want to put on the record that Mr. Martin in the past has not wanted my representation of him. Today, he says it's okay for me to represent him. I just wanted that on the record. I also advise Mr. Martin that his arguments that he makes about sovereign citizens and that is something that I'm not, I can't follow, nor can I ask the court to follow it. Just so that's on the record. As far as witnesses goes right now, Your Honor, would say one.
Okay. Can we approach? I mean, Mr. Gazicki's in the other room. Mr. Gazicki, can you come on in? We'll meet you in the back hallway. All right, Mr. Martin, 1 second.
Yeah, and I got something to say too, while we get time in response to what he said. And for the record, the judge has abandoned court. This case is dismissed. I order this case be dismissed. Case number 25-1756-SM.
All right, guys, you heard it. As per Judge Eric Martin, case dismissed.
All right, we're going to set a bench trial July 14th in person at the 23rd District Court, July 14th at 10 a.m.
Your Honor, can we address bond?
You can address bond.
Okay, Mr. Martin requested that I ask this court if he can have a no condition type bond in this matter.
Okay, here's the problem. I'm just going to say it on the record. Request for a bond modification is denied. Mr. Martin had a very simple bond condition that he not go back to the residence. I know he doesn't think I can tell him that, but he's wrong. And he went back to the residence and got arrested again, allegedly, for being at the home when there was a no contact provision in place. So he clearly has a history of non-compliance. He doesn't think the court has jurisdiction over him. And the only way I can assure his presence and assure the safety of the community is to keep Mr. Martin in custody because he will not comply with my bond conditions. There's no such thing as an unconditional bond. So, okay, bond denied. And Mr. Martin, if you want to file motions that Mr. Gazicki legally could not file in good faith, feel free to file them. He's governed by court rules. He cannot file frivolous motions. So if you want to file more motions, feel free, get it, go at it. But Mr. Gazicki has indicated for the record, he will only be filing appropriate motions with this court. We'll see everyone back on the jury trial. That's my first date.
I have motions to make right now. I have some motions before we leave. I have some motions. Okay, and that is okay. Well, first, objection to what you just said, your statement about there's no such thing as an unconditional bond. Yes, it's my right to be presumed innocent under the due process. The due process right, be presumed innocent before guilty. Because I am presumed innocent, that is why any bond conditions violate that right. So
okay, motion denied. What's your next one?
Okay, and I motion to dismiss because there is no probable cause. It is her word against mine. She's lying. She's been caught lying before. And there is no evidence at all. We have no case. There's no evidence. And that is not probable cause, as the U.S. Supreme Court said in Beck versus Ohio.
Well, misdemeanor, so we're not having a preliminary exam. We're having a bench trial. And the prosecutor will have to prove the allegations beyond a reasonable doubt. And at that time, Mr. Martin, if at trial date, I assure you this, if you picked a bench trial. I was a practicing attorney for years. I promise you this. If she cannot prove her case beyond a reasonable doubt, the case will be dismissed.
Okay, but anyways, let me finish talking. I didn't finish talking about the motion to dismiss.
I know, but Mr. Martin,
as of right now,
what's your last motion? Do you have one more?
You haven't let me finish let me finish the motion just based on no probable cause.
Okay.
As the U.S. Supreme Court said in Beck versus Ohio, or it was Ohio versus Beck, I forget which word is first, but the probable cause is defined as fact sufficient for the belief. Her word against mine. I told the cops she lied on me. Okay, her word against, we simply have her word against mine. That's all there is. So that's
Okay,
not fact
well,
sufficient for the
and
belief.
Mr. Martin,
There's no
I'm
probable
governed by the
cause
jury
now. The
instructions.
case should be, come on, let me
Okay,
finish.
denied. All
The
right,
case
Mr.
should be
Martin, we're
dismissed
going.
now.
We'll see you back on your trial date. Have a good day.
Okay, so we've heard this 3 times in 3 hearings for this case. Beck v. Ohio. He's talking about Beck v. Ohio, 379 U.S. 89 from 1964, and we're going to use the Wayback Machine again to go way back to 1961, a whole 30 years before I was born. So this is in regards to a man named William Beck. We're going to call him Dick Beck from now on because that's hilarious. And the police received unspecified information and reports concerning Dick Beck and his whereabouts for a clearinghouse operation scheme of chance thing. And they went to where he was at, found him, arrested him, searched him, didn't find anything, took him back to jail, found a envelope containing clearinghouse slips, which were illegal in Ohio. And when he got charged with all the shit, he filed a motion and said, yay. Turns out a random person from a payphone using a voice changer saying his name's Steve, turns out that's not like great for probable cause. And the court seemed to like agree with him, disagree with him, whatever, all the way up to the Supreme Court, and the Supreme Court's like, Dick Beck was onto something. So Dick Beck's case is completely different from Eric Martin because Eric Martin's sister, who he lives with, it's not a random person, calling from a different state saying that they did something. No, it's his live-in sister, who he's allegedly put hands on before, calling and saying, my mentally disabled brother, Eric Martin, has put hands on me again. So this case has nothing to do with what Eric Martin has going on in his life. He's just trying to sovereign citizen his way out of a domestic violence case, which doesn't make any sense. But for the rest of this is going to be I told you about the previous case that had to be halted because the guy looked like in the house of the house he was on bond to not go back to. And now they're back, and the person he was next to is now in a car saying, oh, I don't know what you're talking about. But Eric Martin stays there and keeps trying to get the judge's attention.
Okay. Thank you, Mr. Gazicki. That's it, right? Okay.
I have 2 iPhones here. I think
I'm gonna go ahead and handle this hearing and they can, okay. I have 2 iPhones in the courtroom. I need to know your names, please. I have iPhone. Can you unmute and tell me your names? All right. And Mr. Gazicki is meeting with he should be meeting with Mr. Reese at this time.
Yeah,
Mr.
I'm Donna
Reese?
Brewer.
Yeah, Ms. Brewer, I've gotcha. Do we
Okay.
have Mr. Reese here? On the other iPhone, it's muted. I don't know. I mean, we already saw you together. I don't know what good this does, but Mr. Gazicki, I believe this other iPhone is Mr. Reese.